Okay, okay, let me just finish this case and then I'll tell counsel on my other case. Okay, so then let's do this. The court will reinstate the probation for Mr. Cheatham, and then is Mr. Cheatham currently able to pay, or is he requesting any type of community service?
He's advised me that he had lost his job, but he is scheduled to have new employment as of Monday with W.F. Whaley. It's a temporary agency for Chrysler. What he's asking of the court is if the court would give him a total of 2 months to make the total payment of $852, he should be able to pay that outside of what is owed under the payment plan. Is that correct, Mr. Cheatham?
Yeah. Unmute for me. I keep muting you because I get the
Yes, ma'am.
Okay, then let's reinstate his probation. I'll go ahead and reinstate the probation for 3 months. So let's probation reinstated. And the 3 months would give him until towards the end of May to pay. And then what I'll do is I'll put it on the court's docket for I could put it on the court's docket for May the 24th or May 31st, and that way he can pay. And then I'll even put it on for 9/45. And that would mean, you know, we would just know that we just need to check and see if he's paid.
I think that sounds good. Mr. Cheatham, does that work for you?
Yes, ma'am.
Okay, let's go ahead and give him till May 31st. I'll put it on the docket at 9:45.
Thank you very much, Judge.
Okay, so 3 months, May 31st. All right, you're welcome. Have a great day. Stay safe.
You as well. Thank you. Enjoy your weekend.
Thank you.
All right, you're welcome.
Okay.
Okay, counsel on Pilgrim, I'm ready. Although, Ms.
I
Ripley,
am.
I'm going to tell you, Miss Ripley, that I brought Miss Matthews' device in, but she's not connected. I'm going to share my screen to see if she can get connected, see if I can get her to connect, but she's not connected. So give me just one moment, but I'm going to go ahead while she tries to get connected. Let me just put up my share screen. And then also I did want to say that I am live streaming, but because I read all the info, it's a lot of information, and so I assumed that let me try. I assumed that there may be with respect to this particular case, people who wanted to see it because of all the letters and things and such that I did receive. But I just, so that you're aware, I keep getting kicked out of YouTube. So I don't know if there's and I kept trying to go back, but we'll see. Okay, so I'll see if this will allow her to connect. Oh, she did. She's connected. Okay. All right, she's connected. And then Miss Matthews, if you could start your video. This is case number 234466701, the People versus Raymond. Vincent Pilgrim, the defendant, is charged with 1 count of child abuse, 4th degree, and 1 count of assault or assault and battery. Today is the date set for sentencing. Appearances, please.
Good morning, Your Honor. Tina Ripley on behalf of the people, P83688.
Good morning, Your Honor. Lisa Kirsch-Satala appearing on behalf of Dr. Pilgrim. P52675.
Mr. Pilgrim, please state your full name for the court.
Dr. Ramon Pilgrim.
Today is the day set for sentencing, and I did not order a pre-sentence report at the time of the trial. I remember I asked, so I didn't order a pre-sentence report, so we can proceed to the sentencing. And with respect to the sentencing, Ms. Ripley, is there anything on behalf of the people?
Judge, would you like Ms. Matthews to make her statement first and then we can make our recommendation?
If
I'm not
Ms.
sure how you just
Matthews
want to
wants to make a statement, if that's on behalf of the people, yes, Ms. Matthews can make a statement.
Yes,
Ms.
Judge, she did want
Matthews,
to.
can you unmute yourself and tell me your name and well, before I do that, Ms. Ripley, why don't you, for the record, tell us why Ms. Matthews gets to make a statement?
Yes, Judge. Ms. Matthews is the mother of the victim in this case, Isaiah Ashford.
Thank you. And Ms. Matthews, state your name.
My name is Aisha Matthews, the parent of Isaiah Ashford.
Okay, and I understand you want to give a victim impact statement to the court.
Yes.
You may.
Okay. This whole incident that Dr. Pilgrim and my son was involved in, it left a huge impact on my son. You know, it was hard for him to go back to school. Dr. Pilgrim had him banned from coming to school. My son, when he tried to switch schools, he didn't want to be bothered with any male teachers or anything no more. And it just took a lot for him to get over that and overcome that. And like I said, he missed 3 months of school where he had to repeat a grade. So that was a big impact on him. And any males that, you know, play with him or anything, that left like a traumatic experience for him. So I'm glad that this was brought to somebody's attention. It's like it's been a rough year. Unfortunately, it took so long.
Okay. Does that conclude your statement?
Yes.
I do just have one question for you. How old is your son today?
Now he's 12.
Okay, thank you. Okay, anything further on behalf of the people?
Judge, on behalf of the people, Your Honor was the jurist in this case. You heard all of the evidence. You saw the video in this case. What happened here was something that should have never happened, shouldn't have been able to happen. We are asking for a term of probation. We're asking for anger management classes. We are asking for community service and any other terms and conditions that Your Honor sees fit.
And when the people say that they're asking for a term of probation, are you recommending any specific length of probation, or are you just asking for?
We would ask for at least a year.
Okay. Anything further on behalf of the people?
Not at this time, Your Honor.
Okay. Counsel, please state your name for me again. How do you pronounce your last name?
My name is Lisa Kirsch-Satawa.
Okay, thank you, Kirsch-Satawa. Thank you. Okay, do you have on behalf of Mr. Pilgrim?
I do, and I'm going to infer from your comment about reading all of the letters that you have received and read my sentencing memorandum.
Yes,
in this manner. So, as Your Honor is aware, I was not the attorney at the trial. However, I have read the transcripts and the court's ruling, and I would ask the court to consider that this really was an isolated incident that since the incident and this court's finding, Dr. Pilgrim has taken this very seriously. He did have an anger / risk assessment done that we talk a little bit about the conclusions of on page 5 of our memorandum, that he's at low risk for reoffending. He's not highly prone to violent outbursts or would be unable to function effectively in the community. It was suggested by the therapist that he participate in individual therapy to aid him in learning proactive ways to effectively cope with stresses and emotions. He has sought out a therapist already. He has a long time history as an educational professional, as a teacher, as a principal, as an assistant principal. He has been dedicated to children, and especially to troubled children, for most of his career. He's very involved in the community. He mentors youth at risk. This is something just very contrary to who he is as a person, and so we would ask you to also consider that he has no criminal history, no history of substance abuse, no mental health issues, and that the one incident that he did have with law enforcement was over 20 years ago. Actually, take that back. That was wrong. And he really does make a positive impact on the community. That's really who he is. He has definitely learned of how this situation could have been handled differently, should have been handled differently. He's done a lot of reflection. The court knows he has a tremendous amount of support from his past students, his past colleagues, as well as current colleagues. And he really has dedicated his life to shaping and changing at-risk youth to become successful. So, Your Honor, at this time, we would request that you give him a short term of probation, 6 months. He is prepared, I believe, firm with him to pay all of his fines and costs today. And that he will, like I said, he has had the evaluation already. He will continue with his therapist, and he will continue with his community service, because that's who he is. Thank you.
Okay, will Mr. Pilgrim, Dr. Pilgrim, like to make a statement on his own behalf?
I believe he does not wish to make a statement at this time. That was what he told me a few days ago. Dr. Pilgrim, am I correct? You still do not wish to make a statement?
That is correct.
Okay. I was the jurist to preside over the bench trial, and I recall at that time the decision being difficult for me. I recall that I watched the video in order to see if I was seeing what I thought I saw, right? I remember in my verdict saying, that I watched the video. I wished I could have like expanded it to blow it up. But the thing that stood out to me in the video, and I believe Ms. Ripley brought it out in her closing maybe, but I remember the thing that stood out to me was the way that chair, that the force with which Dr. Pilgrim pushed the young boy into the chair caused the chair to immediately, break. And the chairs were lined up, and then all of a sudden the chairs were not lined up. But then I also because at the time, Mr. Pitts, his argument, which was quite convincing, which was also why I just took time to watch the video over and over to see where I saw Dr. Pilgrim's hands. I really think I took a lot of effort to see if the hand was on the chest, which I'm not necessarily sure where I would have landed in my decision if I had concluded that the hand was on the chest. I don't know where I would have landed, but I recall concluding that the hand was not on the chest. I recall concluding that the hand was close to the throat, that the young man doubled over and fell on the floor. I definitely got the sentencing memorandum, and I was reading last night. I printed the sentencing memorandum. I didn't print all of the letters of support that I think when I went to click on print, I was just going to print them, and I clicked on print, and then it said 41 pages. And then I said, oh, my ink is low on my home computer. So if I don't go into the office tomorrow, then I just have to look at them on here. And why am I bringing that up? I have no doubt that Dr. Pilgrim has a lot of support. I have no doubt that he's respected by many of his colleagues. Some of the letters that I received, the people writing the letters were familiar to me. Some of the people that I may know. And some of them was from Dr. Pilgrim's family. And as I read each letter, and they did rave about how great Dr. Pilgrim is and how he's worked, with children. Some letters quoted Martin Luther King to me. They let me know that Martin Luther King and Dr. Pilgrim are fraternity brothers, right? And I don't know if any of the letters brought attention to, my personal sorority affiliation. I don't think so. But I thought every time I read a letter, I said, after I read the letter, I would say, oh, this is a great letter. I wonder, did they see the video? Oh, this is a great letter. I wonder, did they see the video? And then I was reminded of a time in my personal life where I used to be over the youth church group at my church. And I had responsibility to take the kids places. And I remember I used to say, I don't even like kids like this. Why am I in charge of these kids? And some of the kids were very challenging, right? They were very challenging. But then at the end of the day, when they would just come up to me and hug me, and like they would say, thank you for taking us, the baddest ones in the group is come up and hug you and thank you for taking. And then that would make me do it again. And when I did it again, I would be like, I don't even like kids like this. But as I grew, I understood that children come to us the sum total of their surroundings, their environment, their trauma, all of the things that they deal with in the world. We can barely deal with them as adults. So in the moment and that this occurred, I remember, I think also in my verdict, I said, I felt the child may have been difficult. The information that led up to why he was even in the auditorium being escorted by the other person who I don't recall their name or title at this time. I understood the situation. I understood the need to isolate the child. But Dr. Pilgrim, we cannot handle the situation in the way that you handled it. And again, additionally, of course, the thing that bothered me was that after the situation occurred, no one reported any use of force against this child. No one reported until the child didn't want to go back to Dr. Pilgrim after getting in trouble again, but kids could get in trouble 1,000 times. As adults, we have to know how to handle it in the appropriate way. I'm appreciative of the people's recommendation, and I'm taking the people's recommendation in consideration with the letters that I did receive. I am a strong believer with a quote from Brian Stevenson, a civil rights attorney that I respect, that, you know, does a lot of work with death row inmates, and his the quote that he says, "We are better than the worst thing we've ever done," and that people deserve another chance and redemption. I believe that what you did was horrible. I believe that what you did was done in a fit of anger and not caring, not the care that about the other children. There's a book that I read on a regular basis, and it says that I will leave the 99 good people over here to go after the one lost person over here. The victim in this case was lost and needed some adult male appropriate supervision. And I believe you all failed him. I do believe you failed him. However, I don't think it should destroy your life, nor do I think it should destroy your career, nor do I think it should destroy your reputation. Our reputations are our reputations. They come with the decisions that we make. So I don't believe that your life should be over, but I do, of course, believe you should take responsibility and accountability. I felt like the letters were really nervous that I was going to put you in jail. And I will say that I've considered it. I will say that I considered it. After I replayed that video in my head. But I believe that you are a pillar of your community. But we have to shine the light on this type of behavior so that it doesn't continue. I'm going to accept the recommendation from the prosecutor with respect to a term of probation, and I asked the prosecutor if they were recommending a particular length of probation. They said 12 months. And so I'm going to go with the 12 months. I'm going to go with the 12 months because I'm telling you, again, after I came down from any jail time, even to hold it in abeyance, right? I think I have confidence that you'll do the probation, but sometimes I would say jail time held in abeyance as long as the person does the sentence. I have no doubt that, I mean, Dr. Pilgrim has expended a lot of energy. I could tell by the letters, by what the letter said, by all of those things. So I'm going to do the 12 months probation. I will well, at this time, I'll do the 12 months probation. So I'll place you on probation for 12-month period with a final review date of February the 25th of 2000 and, well, let's make it February 21st, which would be the Friday, 2025. Court will give a midway review date of August the strike that, August 29th. 2024 at 10:00 a.m. The probation carries the following terms and conditions. You shall not violate any criminal law of any governmental unit. You must not leave the state of Michigan without the consent of the court. You must make a truthful report to probation on a monthly basis, and you must notify probation immediately of any change of your address, phone number, or employment status. You will pay the following fines, costs, and fees. Mandatory cost of $210, a $500 fine. Ms. Ripley, you didn't say anything about restitution. I know Ms. Matthews was just kind of talking about how difficult it was for her son, but there are no like counseling bills or anything like that.
I'm not aware of any, Judge.
Ms. Matthews, you didn't have any out-of-pocket expenses with respect to your son following this incident, did you?
No, I didn't. Our insurance paid for it.
Okay, thank you so much. All right, the court is then going to set restitution at $0. I am going to impose $420 probation oversight fees. That is at a rate of $35 per month. And I did not do a pre-sentence investigation fee, so there is no fee for that. The court is also going to impose, I'm not going to order random urinalysis, but I am going to order at the discretion of probation. They may order, they may require Dr. Pilgrim to submit to urinalysis at their discretion if they see any need. And then at that time, they can submit a request for the court to add any fees if the testing is at the court. The total fines, costs, and fees is $1,130. Additionally, you shall not use or possess any illegal substances. You shall not use or possess any marijuana without a valid medical marijuana card. You shall not use or possess any opiates without a valid prescription and letter of explanation from the doctor. You shall not drive without a valid driver's license. You shall attend 12 weeks of anger management through eVay, and you shall complete 10 days of community services at a place approved by the probation department. You shall pay any outstanding tickets that you have with the 36th District Court. You shall clear up any warrants that you have, if you have any outstanding warrants, and then you shall have no contact with the complaining witness. I did have a question. I do apologize. Where does Dr. Pilgrim work now?
I don't believe that he has been.
Oh, did you put
working.
that in? Maybe you put that in your memorandum?
I believe I did.
I thought I saw it. I think I did. Okay.
It's on page 2. That
Yes. Okay.
and he yeah, right now he's just been working with his all male mentor group.
Okay. Yeah.
And just continues to do community work.
Okay. Thank you.
Am I correct, Dr. Pilgrim? I just want to make sure I didn't miss something.
No, you are correct.
Okay.
So I do believe that outside of this particular incident, at least we're not aware of any other incidents with Dr. Pilgrim and any what I would call inappropriate contact with the children, inappropriate physical, contact as like the subject of this case. So I don't, as with respect to his probation, the court is not going to restrict him from working with children. So if he's able to get, a position, the court is not restricting him. So there's not going to be a restriction against him working with children. And then I don't know. Yes, I think I did say that the 10 days. Oh, let me just clarify the 10 days. A day is 8 hours. So 10 days translates to 80 hours. That's how that works. And I think that's going to be the order of the court. Is there anything further with respect to this on behalf of the people?
Not on behalf of the people, Your Honor. Thank you.
On behalf of the defense?
Your Honor, if he has accrued community service hours between the trial and sentencing, would that be satisfactory as credit? It wouldn't be hit the complete amount, but would that be credited towards his 80 hours?
Do the people have any position on that?
Judge, we'd leave it in the discretion of the court.
Okay. I'll give them credit up to half.
Okay.
And that is, counsel, I do apologize also. That is, as long as the place that he has done the community service is approved by probation. So wherever
Absolutely.
he's done the community service, it still has to be a place that would have been approved by probation. And then they can, if they approve where he's already done the community service, if they want to allow him to continue, doing community service at that agency, they can. But I don't want to step outside of them because they have certain requirements that the agency has to have in order for us to accept the community service. So I think it's some dealing with insurance and certain certifications. Okay.
Yep, absolutely.
So I'll accept up to half of those hours. Okay.
Just one last thing, Your Honor.
Oh, yes. Okay.
I could tell by both the way your opinion and ruling at the trial and the amount of time that you spent on this case today that you took great care. And thank you for all of your attention.
Oh, you're welcome, counsel. Thank you. I appreciate that. All right. Then I think we're all set. And then, of course, if I didn't say so I will address your request to me for a 6-month probationary period. I meant to do it. And the reason I declined to do that is because the law already requires for the court to grant an early discharge after the halfway point if the individual has completed the terms and conditions of their probation. And so in this way, Dr. Pilgrim is eligible for early discharge at the 6-month mark, but I did not want to have him eligible at the 3-month mark. So that's why my ruling is the way it is. Okay. All right. Anything further?
No, thank you very much, Your Honor.
All right. Then we're all set. Everyone have a great day and stay safe.
Thank you, Judge.
You're welcome. Okay, Ms. Stevenson, Mr. Thomas is in the room, but he doesn't have a plus sign, and I think he left and came back. Did you talk to him?
I did. We do not need a breakout room, Your Honor. I'm just not sure which of those devices will be working for him.
Okay, then I'm ready on Big
Oh,
This is case number 204427301, the People versus Angelica Denise Bigby. Defendant is charged with driving while license suspended, revoked, denied, operating while intoxicated, and today is the date set for sentencing. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
Janice Stevenson appearing on behalf of Ms. Angelica Bigby. Ms. Bigby, ma'am, please say your full name.
Angelica Denise Bigby.
Today is the day set for sentencing. With respect to, and the court has had an opportunity to review the pre-sentence investigation. With respect to the report itself, are there any additions, deletions, or corrections on behalf of the people?
Your Honor, the people had an opportunity to review the pre-sentence report, and I don't see any additions, deletions, or corrections on our behalf.
And on behalf of the defense?
Thank you, Your Honor. Ms. Bigby and I have had the opportunity to review the pre-sentence investigation report. We do find it to be factually correct. We have no additions, deletions, or corrections at this time, and Ms. Bigby does stand ready for sentencing.
With respect to sentencing, anything on behalf of the people?
Nothing on behalf of the people, Your Honor.
On behalf of the defense?
On behalf of Ms. Bigby, Your Honor, we would advise the court that although Ms. Bigby is currently under sentence for a similar offense, this offense does predate that for which she's under sentence. And it really would be our position that had there been, some type of intervention earlier on at the time, closer to the commencement of this case, that maybe the second case would not have come about. Your Honor, with regard to that first case, Ms. Bigby has advised me that she was not aware that the matter was outstanding, that it had been previously dismissed without prejudice, and that the warrant was the case for which she is before you now. That it had been dismissed without prejudice and that the warrant was reissued. So that's why she didn't know that the warrant was outstanding. Otherwise, she would have jumped on top of it. And again, had she been able to do that, maybe the second case would not have come about. I had a conversation with Ms. Bigby as to whether or not she has been able to get started on the probation in the later case, Your Honor. She has done some of the conditions of probation, Your Honor. We would just, and she'll talk to you about what kind of benefits she's derived through having started probation already. We would just be hoping that first of all, that she would be able to be placed on probation and then supervised by Officer Hunter. He's supervising her on the Z-ticket case. And hopefully that the court would consider giving her credit for any conditions of probation that this court orders her to do that she's already completing under the other probation. I've already talked to Ms. Bigby. Even they gave her the Alcohol Highway Safety Education Level 2 course. So I did advise Ms. Bigby that there's a possibility that this court would sentence her to the Level 1 course. I don't know about that, but she's prepared for that if that's what's going to happen. We've talked about these outstanding warrants. We've talked about, most importantly, put a plan in place for her to go ahead and take care of the outstanding felony warrant that's referenced in the current conviction section, because she risks being arrested if she's out and about on that one. So we've gotten a plan in place for within the next 7 or 8 days for Ms. Bigby to go ahead and take care of that matter, and then move toward clearing up any other matters that she has in this jurisdiction or any other. So I am asking the court to, I'm also asking the court not to just hold off on the probation department's recommendation of referral to the Veterans Court, or Drug Treatment Court, to the specialty court at this time, just to see whether or not she's able to respond favorably to these, what I hope would be 2 probations that she's under. Again, she does understand that if this court places her on probation, that there are 2 separate probations. And so she knows that she's got to get permission from this court rather than, just assume that anything she does on the other probation is going to be satisfactory for this probation. There will be 2 separate matters, and Ms. Bigby understands that. And
unless we send her to sobriety court where she should be, and then they combine the cases, and then she only has to worry about that she's doing it right there together.
Yes, absolutely. And I guess I don't know if that was a recommendation for the newer case. If, you know, and if they gave her the alcohol highway safety education level 2, I was just thinking that, you know, maybe it would have been more logical for them to send her to the sobriety court, which would have, I think, almost automatically brought this case in. So
no, there's never an automatic sobriety court is nothing automatic about sobriety court. However, it usually will happen because the judges will agree.
Mm-hmm.
And I think that's where she needs to be, but I'm gonna let you keep talking.
Yeah, I am, you know, at least until, you know, we get a better sense of what's gonna happen with that felony matter. Because I just don't want to set Miss Bigby up for failure. She's, you know, had a lot going on in her past, but I think when the court hears from Miss Bigby, it'll get more of a sense of, you know, how favorably I believe Miss Bigby would respond to a sentence of probation.
Okay. Would she like to address the court?
Ms. Bigby, would you like to say something to the court? If so, this is the time.
Yes, Your Honor. During this time, I have taken time out to complete some of the I did the consequences video, Your Honor, and I am aware that drinking and driving isn't a thing that I should be doing, and I don't have a problem with being sober. I've been sober for months now. I can do a clean drug test any day, and I just been through a lot recently. I just lost my mom, so that kind of led me to overreact and like act out of impulse. But now I'm working on that, and I've been sober for months. So.
All right, the court is ready to impose sentence. I'm going to accept the recommendation from probation for a 20-month probationary period, 24-month, probationary period. At this time, I won't refer the case to sobriety court since this case is the first in time, though she has the second case. And I think they should have referred her to sobriety court. I'm going to, Mr. Flanagan, can I get a February 2026 date after or around this same date?
Yes, Your Honor. Friday, February 20th, or Monday, February 23rd, 2026.
I'll take the Friday, February 20th, 2026 for the final review date. Of course, this would definitely be a reporting probation, and we will indicate that Mr. Hunter is already supervising her, so the case should be assigned to Mr. Hunter. She has little room to mess up because otherwise I'm sending her to sobriety court. I'm going to set the matter for a review in 3 months, see how she's doing. Let's come back May 31st. Wait, am I here that day? I am not. Let's come back June 4th. At 10 o'clock a.m. Court is going to impose following terms and conditions. You shall not violate any criminal law of any governmental unit. You cannot leave the state without consent of the court. You must make a truthful report to probation on a monthly basis and notify probation immediately of any change of your address, phone number, or employment status. You will pay the following fines, costs, and fees. This has nothing to do with your other probation. This is separate and apart. from your other probation. You will pay mandatory costs of $210. She has two, what? I'm sorry. Yeah, she has two counts. So on count one, which is the operating while intoxicated count, the court is going to impose a mandatory cost of $210. And then on count two, also the mandatory cost of $210. On count one, the court is going to impose a $100 attorney's fee. On count one, the court is going to impose a $500 fine. On count two, court is going to impose a $200 fine. No restitution. The supervision fees will only be on count one, $840 at a rate of $35 per month. Now, what I will say is she being charged oversight fees on her other case?
Yes, Your Honor.
At a rate of what?
Mm.
Mr. Flanagan, can you pull up her Z ticket?
Yes, Your Honor, I have it up.
How much did Judge Yancey charge her for the oversight fees?
$630.
So that sounds like it's at the full rate. Okay, so I will actually reduce her oversight fees. I'll only add $10 extra to because it'll just still be Mr. Hunter. Well, can you call Mr. Farmer and ask him if he's going to assign this to Mr. Hunter since she's already being supervised? Otherwise, I'll impose the full oversight fees.
Yes, Your Honor.
Okay, so I'll double back to that. And then the $100 pre-sentence investigation fee. Did Judge Yancey charge any urinalysis fees? Do we know? She has to be getting tested because, well, she's supposed to be getting tested. That's what the law requires.
$360 for your analysis fee, Your Honor.
Okay, so she charged her for the urinalysis. I won't charge her but the requirement is testing. She's going to test twice a month. And of course, it's whatever, twice a month period. So whatever Yancey has her doing, she doesn't have to double that. And then I'll wait to hear. So let's make a note charged on Yancey case. I want to make sure I know why I didn't charge anything. All right, so I'll get back to you with the totals. The total on count two is $410. That's not going to change. The total on count one is what I have to look at. Additionally, you shall not use or possess any illegal substances. No marijuana without a valid medical marijuana card. No opiates without a valid prescription and letter of explanation from the doctor. You shall not consume alcohol in any shape, in any form. No driving without a valid driver's license. Alcohol highway safety level 1. As I said, urinalysis twice a month. Victims impact panel and the consequences video. The court is also going to order outpatient treatment and driver's improvement program. Pay any outstanding tickets with 36th District Court. Remain in compliance with the Z ticket probation. And as I indicated, I won't refer to sobriety court, but if she's test positive like one time, I'm going to refer her. All right, any response from Mr. Farmer? Oh, you might have sent me a message in the chat. Hold on. Okay, yes. All right, so then I'm not going to charge her for the oversight fee because she's getting it. I mean, I'm going to only add $10 on the oversight fee because she's getting it on the other case. So her oversight fees are $240 instead of the $840. So the total on count one is $1,050, and then the grand total is $1,460. And then, Mr. Flanagan, let's just put it in there, any positive tests refer to sobriety court. And then if I didn't say it, she needs to clear up her warrant, and then specifically the felony warrant out of the 24th District Court. Oh, I'm not sure. I'm not sure how that's reading, but that felony warrant must be cleared up by the first review date of June 4th. Must. She cannot be in warrant status on that felony case when June 4th come around. Anything further?
Not from the people, Judge. Thank you.
Your Honor, what I'm rolling around in my mind is that she is under I think that with Mr. Hunter's supervision, Ms. Bigby would not be required to submit to random urinalysis 4 times a month.
I already said that. You wasn't paying attention earlier then.
I was. Okay,
so I said only twice a month. Only twice a month for all the cases. Only twice a month. I said only twice a month. So I will accept the twice a month from the other case.
Okay, that was the language I was looking for. Thank you, Your Honor.
I mean, why do I have to say it a specific way?
You don't, Judge.
I don't know. Okay, anything further?
Ms. Bigby, no, I don't have anything further. Ms. Bigby, do you have anything for the record, ma'am? Okay, nothing further on behalf of Ms. Bigby. Thank you, Your Honor.
All right, then you're all set, ma'am. We're going to mail a copy of the order to the Elmdale Street address. Probation is going to contact you at the phone number ending in 9798. Have a great day. Stay safe.
Okay, you too. Thank you, Your Honor.
You're welcome. Whew. Okay, I'm ready on he done waited a long time for this discharge. Let's go with Mr. Knudsen. Mr. Knudsen, good morning. We still in the morning. All right, Mr. Knudsen, I just looked at your review. Thank you so much for your patience. I just said you waited a long time for me to get to you for this review, for this discharge. All right, so let's go ahead and do Mr. Knudsen. This is case number 214469301, the People versus Christian Appleby Knudsen. Defendant is charged with assault or assault and battery. Today is the day set for review. Ms. Stevenson, your appearance.
Janice Stevenson on behalf of Christopher Knudsen. Mr. Knudsen, sir, please unmute and say your full name.
My name is, Christian Appleby Knudsen.
Knudsen, thank you, sir. Today is the day set for review, and according to Ms. O'Driscoll, Mr. Knudsen has completed anger management, 12-step program, negative drug screens, has had no contact, does not owe any tickets, paid all of his fines, costs, and fees. He was placed on a 14-month probationary period, and he's supposed to get off probation in September. I believe this is his halfway point. Let's see, September. Yes, this will be halfway. Ms. Stevenson?
Thank you, Your Honor. Move for dismissal pursuant to MCLA 771.1.
Who said it was taken? How can a 14-month be taken under MCLA?
I checked the ROA, Judge.
Oh, I must have said if he finished early, I would give it to him. because they can't do a 771 for 14 months. But did I do 77? Did I say, was this a delayed sentence, Mr. Flanagan?
It's not on a delayed sentence probation form, but it is a delayed sentence, yes.
Why do you say that?
I see it in the ROA, July 21st, 2023. The order of delayed. I'm sorry.
Anybody could have put that in there. Y'all could have did whatever y'all wanted to do. Did I say delayed sentence on his probation form?
I'm reading it, Your Honor. It is not on the probation form, no.
All right, let's see. Did this come down? This didn't start out as a felony, did it?
No.
All right, well, since he is finishing short of the 14 months, the court will dismiss the matter pursuant to MCLA 771.1 and discharge Mr. Knudsen from probation with improvement, close the case out and remove conviction. You're all set, Mr. Knudsen. We'll mail you a copy of the orders for your record, sir. Congratulations and good luck to you.
Thank you so much, Judge. You've been very fair.
Oh, thank you, Mr. Knudsen. I appreciate that. You have a great day and stay safe.
You too. Bye.
Bye-bye.
Do I need to stay on the Zoom call?
No, sir. I'm gonna remove you. All right.
Okay. Thank you.
You're welcome. Mr. Thomas, oh, there he is. I was gonna say he was having trouble earlier. Start your video, Mr. Thomas. All right. Mr. Thomas, you so sharp right now. Mr. Thomas, are you was putting that jacket on for court?
Yes. Yes, ma'am. Yes, ma'am.
Oh, Mr. Thomas, I wish I could screenshot you and just put you up on a billboard, but okay. Mr. Thomas, I appreciate you. I appreciate you coming to court appropriately. That's a nice jacket. All right.
Thank you. Appreciate it.
This is case number 214562901, the People versus Corey Jerome Thomas. The defendant is charged with operating while intoxicated. Today is the day set for review. Ms. Stevenson.
Janice Stevenson appearing on behalf of Mr. Corey Thomas. Mr. Thomas, sir, please say your full name.
Corey Jerome Thomas.
All right, today is the day set for review. Mr. Thomas was placed on an 18-month probation in 2003. So in May, his 12 months is coming up. It will be 12 months in this coming May. You've done a phenomenal job so far, Mr. Thomas. According to the report from Probation Officer Tucker, you've done a phenomenal job so far. You do still have a balance of $210 and some outstanding tickets. Ms. Stevenson?
Your Honor, I first want to commend Mr. Thomas for doing his very best to listen to his mother, who's helping him move through this probation. Mr. Thomas, to be forthright, did have a couple of hiccups, which he has absolutely turned around. The information I have is that there's a zero.
Is this the one that she sent an updated one on? I'm sorry.
No, that was for today. No, that was Mr. Giles.
Mr. who?
Joseph Giles, who did a plea today.
Oh, she sent some updated information?
Somebody did. I don't know.
No, I thought I sent you. No. Oh, well, go ahead.
Okay. So it looks to me like at this point, I'm going to be asking the court to go ahead and get to it, to go ahead and early discharge Mr. Thomas from probation. I believe there is currently a zero balance on this case. I spoke with Ms. Tucker this morning. In her report to the court, she lists 3 outstanding traffic matters which have to be taken care of. My review of the Register of Actions is that the first 2 tickets that she lists are payable. They're due on March 11th with Judge Ruth Garrett. The final
hold on. So just for your information, this is the case that she sent the update on, and she removed the 210. So she did
Oh,
say
okay.
this
Okay, I
is
don't know if yeah.
okay. And I sent it to you, but you probably didn't look at it.
No. Well, maybe I looked at it, but then I only looked for the parts that I was interested in. So the tickets. So there's the SX ticket that has a 0 balance on it right now. So he
Mr.
has
Flanagan, can you confirm that the SX ticket has a 0 balance? And confirm that the SP ticket has a court date beyond today?
they don't have court dates, they have payment due dates.
Mm-hmm. Payment due dates beyond today then?
And so with that, when Mr. Flanagan confirms all that information, I'm again asking the court to go ahead and release Mr. Thomas from probation so that he can get to work at Aetna. He has a job that is waiting for him to have this behind him, and he's ready to do that, Judge.
All right. Mr. Flanagan, let me know.
Yes, Your Honor. Ticket SX 37657321 has a 0 balance.
Okay.
And for the other one. And for SP 13897-961, the balance is $245.
But when is the payment due?
March 11th, 2024.
Thank you.
Mhm.
All right, Mr. Thomas.
Yes, ma'am.
Whatever your hiccups were, I don't know who got you together, your mother or whoever. Now, if she's anything like me, she might have been good at getting you together. But I don't know if she do like me, and I tell my kids, now don't go out here embarrassing me and people know you my child.
Right.
You gotta just, they know you got a mother. If they look you up, they gonna know it's me. You've done a great job. So whatever your hiccup was, you fixed it. And that's great. You even completed 100 hours of community service. You've done a great job. You've done a great job. And since the one ticket is a 0 balance and the other ticket has a due date of March 11th, I am going to grant your attorney's request, and I'm going to discharge you early from probation with improvement and close the case out.
Thank you, Your Honor. Thank you.
You are very welcome, sir. You have a great day and stay safe.
Thank you, Your Honor.
Appreciate you. Appreciate you.
Yay, Mr. Thomas. Yay. Yay. That's right. That's right.
All right. You have a great day. Stay safe, Mr. Thomas.
Thank you. You too as well. Appreciate you, Your Honor.
Mm-hmm. All right. I'm ready on Plunk. This is case number 214533001, the people of the state of Michigan versus Robert. Middle name is Deartiz Plunk. The defendant is charged with operating while intoxicated. Yesterday was the date set for final pretrial conference. Mr. Plunk was having some technical difficulties and the court allowed him to come today. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
Janice Stevenson appearing on behalf of Mr. Robert Plunk. Mr. Plunk, sir, say your full name.
Robert D.R.T. Plunk.
Thank you, sir. Today is the date set for today is final pretrial conference. It's at 9. It was at 9:10. When is his trial?
There wasn't one in there that I saw.
Oh. Why did he get a 9:10? Okay. Ms. Stevenson, how are we proceeding?
Thank you, Your Honor. Mr. Plunk and I have talked about this case. He's had the opportunity to execute an advice of rights form and review that form with me. It is my understanding that at this time, Mr. Plunk wishes to waive his rights incident to trial and offer the court a plea of guilty to one count of operating while intoxicated, unless the people are offering OWBI.
I believe the people's offer was a charge reduction to operating while visible impaired.
Okay. So, Mr. Plunk, the people have offered you a reduction to operating while visibly impaired. Your lawyer says you want to accept that offer. Is that what you want to do?
Yes.
All right, Mr. Plunk. I'm going to share my screen. Mr. Flanagan, can you just check and make sure that there's not a trial somewhere holding a space for Mr. Plunk? Mr. Plunk, I'm going to share my screen. And on the screen will appear a constitutional rights form. My question to you is, have you had an opportunity to review for yourself or to go over with your lawyer your constitutional rights?
Yes, ma'am.
When you did that, did you understand your constitutional rights?
Yes, ma'am.
You got to speak up a little bit for me.
Yes, ma'am.
Thank you. Do you understand that this is a misdemeanor and therefore you have a right to a trial, but if I accept your plea, you are giving up your right to a trial as stated in number 6?
Yes, ma'am.
Has anyone threatened you in any way or promised you anything that was not placed on the record to get you to enter into this voluntary plea?
No, ma'am.
Drawing your attention to number 8. Are you currently on probation or parole?
No, ma'am.
Finally, drawing your attention to number 11. Do you understand that if I accept this voluntary plea from you today, you may be giving up your right to an automatic appeal, and if you were to change your mind about the plea, you would either have to request permission of the circuit court to appeal the conviction or request permission of this court to set aside the conviction. Do you understand?
Yes, ma'am.
With that understanding, do you still want to enter into this voluntary plea?
Yes, ma'am.
Raise your right hand for me, sir. Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
All right. And by the way, thank you for being patient, Mr. Plump, while I put all today's cases ahead of you.
No problem.
Okay. You were patient. I didn't even see you looking like you was gonna wanted to scream at us. So thank you. Ms. Stevenson.
Thank you, Your Honor. Mr. Plum, on August 19th of 2021, were you operating a motor vehicle in the area of northbound M10 freeway at Webb Street in the city of Detroit?
Yes, ma'am.
And prior to operating that motor vehicle in that location on that date, did you consume alcohol?
Yes, ma'am.
And did the consumption of that alcohol interfere with your ability to safely drive that vehicle?
Yes, ma'am.
Thank you. Your Honor, for purposes of the plea, we would stipulate that the blood alcohol content was 0.13, and with that, defense is satisfied.
Are the people satisfied?
Are satisfied, Your Honor.
And people stipulate to that blood alcohol?
I'm sorry, so stipulated for purposes of the plea, Judge.
Court accepts the stipulation, and with the stipulation accepts a plea of guilty to an amended charge of operating while visibly impaired. Having accepted that plea, the court is going to set the matter for sentencing. Mr. Plunk, I normally try to set the sentencings within 4 weeks. However, due to my much needed vacation schedule, I'm going to have to schedule you about 8 weeks out based upon the court's docket and vacation. So I'm going to schedule you for April 19th. And then prior to the sentencing, you must submit to a pre-sentence investigation and substance abuse evaluation. Mr. Plump, you have a right to be sentenced on Zoom, or you can consent to be, I'm sorry, I'm saying it backwards. You have a right to be sentenced in person, or you may consent to being sentenced on Zoom. Which do you prefer, sir?
I'm probably gonna come in, so I had the same situation in AT&T.
Yeah, and you know, AT&T was playing yesterday because my phone wasn't working either, Mr. Plump. So I did understand, but that's why I wanted you to come in yesterday. But you know, yeah, I don't know what I said. I was going to take the time to look it up and see what caused that outage, but it did cause a little problem. So I'll schedule it for in person. However, Mr. Plump, if you get to that day, so I'll put it for 9:02, but if you get to that day and all your devices are working properly and you want to Zoom in for your sentencing, you may, okay?
Okay.
All right. Anything further with respect to Mr. Plump?
Not from the people, Your Honor. Thank you.
I'm sorry, Judge. I was doing something else. What the date was April what? I'm sorry.
I like the way that we just can be so honest with each other on here. I'm just so Ms. Stevenson was like, Judge, I wasn't listening to you. Give me that date again. April the 19th
Okay.
at 9:02. And then Mr. Plunk, since you're in the building, if you have time, you could go across the hall to room 317 so they can go ahead and schedule your pre-sentence investigation and substance abuse evaluation. If you don't have time, because I know you've been sitting a while today, they will call you. They'll contact you. Okay?
Okay, I'm just gonna work.
Say that again.
Just wait on the call, 'cause I gotta go to work.
Okay, well then they'll call you and set up that in pre-sentence investigation. All right, have a great day. Stay safe.
Thank you, Your Honor.
You're welcome. All right. Whew. And then now I guess I will do Ms. Jefferson as well, who I don't know if she was really as affected by the AT&T because she came yesterday, but that's all right. This is case number 224488501, the People versus India. Danae Jefferson, the defendant, is charged with 1 count malicious destruction of property. Yesterday was the date set for pretrial conference. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
Janice Stevenson appearing on behalf of Ms. India Jefferson. Ms. Jefferson, ma'am, please unmute and say your full name.
India Jefferson.
What name? Don't you? Did you say a middle name? Yeah, Ms.
India.
Jefferson. What's your middle name?
Danae.
Thank you. Mr. Flanagan, yesterday when Ms. Jefferson didn't appear, did I put a warrant out for her arrest?
No.
Yeah. Did I give her another date? I thought she was a capias.
Oh, she was. Yes, Your Honor. Yes. My
She
apologies.
was a capias. Okay, so Ms. Stevenson.
First requested any outstanding capias be set aside and the warrants recalled, and we thank the court for hearing Ms. Jefferson's matter today, Your Honor. We appreciate that.
Court will set aside the capias and recall the warrant that was issued yesterday. Ms. Stevenson.
Your Honor, I would ask that we be able to immediately to pretrial conference. And that yesterday was the adjourned pretrial date. And I would state I do not believe that the complaining witness was present. So I'd ask for dismissal, Your Honor.
Ms. Ritter.
Your Honor, so yesterday was at least the second scheduling of the pretrial conference, and the people don't recall speaking with the complaining witness, Ms. Shantez Chambers. Either do the people recall seeing Ms. Chambers in the waiting room yesterday? People have no explanation as to why Ms. Chambers did not appear yesterday, as it was scheduled for the second pretrial conference, and she was required to appear by the court. So at this time, Your Honor, the people will not be able to proceed based on the complaining witness's failure to appear yesterday at the second scheduling of the pretrial conference.
All right, so yesterday was the date set for pretrial conference. And as I indicated, I have a note. Well, there's two things that were going on. Ms. Jefferson's name is highlighted in pink. That means that she actually did show up. And then I wrote next to her name as we were going through the cases that she left and didn't return. What is not on my docket is a CW. That means that the complaining witness did not appear yesterday. I do have CWs next to other cases, but not this one. So with respect to that, the court having set aside the capias and recalled the warrant, The complaining witness was required to appear on yesterday. They failed to appear, and the people have no explanation for the failure. They are unable to proceed. The court is going to grant defense counsel's motion, and the matter is dismissed without prejudice. Ms. Jefferson, we will mail you a copy of the order of dismissal for your records, ma'am. Anything further with respect to Ms. Jefferson's matter?
No, thank you, Your Honor.
Nothing on behalf of Ms. Jefferson. Thank you, Your Honor.
All right then, Ms. Jefferson, you're all set. Have a great day and stay safe.